Welcome to Mediation, the New Possibilities Hour. It is July 14th, 2020, and we're very happy today that our guest is Phyllis Pollack to talk about ethical issues in mediation. Phyllis is the principal of PGP Mediation. She's been a mediator in Los Angeles since 2000 and has conducted over 2,000 mediations. She's a past chair of the State Bar of California's Alternative Dispute Resolution Committee. She has served on the board of the California Dispute Resolution Council and is a past president of the Southern California Mediation Association. At present, she also serves as a lecturer in law at the University of Southern California's Gould School of Law, teaching ADR ethics and co-teaching online employment dispute mediation. Phyllis, we're very excited to have you here today. The floor is yours.
Thank you very much, Jeff. I assume everybody can hear me. First of all, I want to thank everybody for showing up, particularly if you're on the West Coast where it's 8 a.m. in the morning. I know it's a bit early. I'd also like to wish those who might be in France a happy Bastille Day. I know, it's a big event, almost like our Independence Day. I want to spend approximately the next 45 minutes discussing some ethical considerations in online mediations. As you know, they have taken on increased significance since the COVID-19 in March. And so I want to just give you all some thoughts to think about when you do your next online mediation. And to do that, let's look at an outline, if I can get this right. And what I'll discuss is first some definitions that are related to online dispute resolution, briefly go through the history of online dispute resolution, some ethical principles, some standards, some guidelines or practical do's and don'ts for video mediations, and then apply them to the model standards of conduct for mediator and the issues that they may raise under the different model standards. And depending upon what y'all want to do, either go through some hypotheticals or answer some questions that you may have. So the first is definitions. And the first one is obviously online dispute resolution. And online dispute resolution is essentially a branch of ADR or alternative dispute resolution, which uses technology to resolve disputes using either negotiation, mediation, arbitration, or a combination. Prior to this COVID-19 that we have, it was used mainly to resolve electronic disputes or e-commerce or internet-related disputes that were typically cross-border and involved minimal sums that made it too costly to use traditional forms of dispute resolution. For example, eBay says that it resolves more than 60 million disputes a year online, 90% of them without a mediator. The next is information and communication technology, and this is simply a marriage or a convergence of telecommunications and computers. It is combining the audio-visual and telephone networks with the computer networks. It is an umbrella term encompassing any communication device such as radio, TV, cell phones, computers, network hardware, satellite systems. So it includes more than just Zoom. It includes telephone, fax, emails, text messages, software apps, your Skype, your Google Docs, video conferencing such as GoToMeeting, Zoom, Google Hangouts, WebEx, FaceTime, etc. The fourth party refers to the technology that is being used. It is a term that was coined way back in 2001 by Ethan Cash and Janet Rifkin. So it refers to your WebEx or your Zoom or your Google Hangouts. And your fifth party, if I can get this, is the provider of the technology. So that would be the owners of Zoom, the shareholders of Zoom, or the operators actually, or the owners of Google Hangout. And just as an aside, the third party would be the mediator. So you have your first and second parties would be the participants, the third party would be the mediator, the fourth party is the technology, and the fifth party is the owner of the technology. So to go through a little bit of history, in 1969, the internet was invented, and I don't know if Al Gore was truly the inventor, as everybody says. In 1985, the domain name system was created. The first internet service provider appeared in 1992, and this year is also critical because that was the year that the National Science Foundation, which was then the manager of the internet, authorized the use of internet for commercial purposes. And with that, Amazon launched in July of 1994, eBay launched in September of 1995, and with it came a whole bunch of disputes. So that between 1999 and 2008, eBay was using SquareTrade, and then you also had other websites such as CyberSettle and Mediation Room to settle all of these online disputes. And remember that they were mainly cross-border and of minimal sums. And so that is why the internet became so popular to resolve them. There are mainly two organizations that are involved with this online dispute resolution technology. The first is the National Center for Technology and Dispute Resolution. It was founded in 1998 and is academic based out of the University of Massachusetts and Amherst, and it is involved in the development of the theory and practice that supports ODR. At its meeting in 2017, it created the International Council for Online Dispute Resolution, which is a nonprofit consortium that is incorporated in the United States, and it is involved in the development, the convergence, and the adoption of open standards for the global effort to resolve disputes online. The National Center came up with a bunch of principles, and there's 17 of them. And the principles deal with the design as well as the procedure and substance, and they are aimed as overall mediation principles. They are values and not rules. And I want to take a moment to go through them. A lot of them are probably self-evident, but it will kind of give you a flavor of where these online dispute resolution organizations and the people involved in it are coming from. Accessibility is somewhat apparent or self-evident. They want the design and implementation of the online dispute resolution system to reach the broadest range and number of people, but also accounting for the cultural differences. And it's also very important that those who would otherwise have their voices marginalized or silenced, that is, be the subject of a improper power imbalance, be heard and have equal access to the system. By accountability, these folks mean that the development and the implementation of the system should be accountable to all the institutions, the legal frameworks, and the communities that they serve. Competence, again, is somewhat self-evident in that the systems and the process and the practitioners using the online dispute resolution should be competent not only in the alternative dispute resolution process, but should also be competent in the technology and also competent in the language and culture, because remember, a lot of these disputes are cross-border, so you have different languages and different culture involved. By confidentiality, again, that's obvious that the process used, the implementation of the process, should maintain confidentiality in accordance with all legal obligations. Empowerment what the design and the process used for the online dispute resolution should provide access to justice, enhance the choices and effective decision-making opportunities of all those involved. By equality, these folks mean that the process should treat all participants with respect and human dignity, and again, ensure that those voices that might otherwise be silenced or marginalized have equal footing, be heard, that they are not placed at a higher risk than others, and that the system responds to the reality of the situation, because I'm sure that many of you in mediations have had to deal with power imbalances and other unequal situations. And so by this principle, they want everything to try to be on a level playing field. In terms of fairness, the folks who design these processes want to uphold due process without bias or benefits for or against individuals, and also to pay particular attention to the algorithms that are involved. I know that, we've heard a lot, particularly with Facebook, how the algorithms are coded so that they may be unfair or unequal. And these folks want to make sure that that doesn't occur in whichever ODR process is used. Honesty, again, is self-evident. This is in terms that the data is gathered, managed, and presented in ways not to ensure that it is misrepresented or taken out of context. By impartiality, they want to make sure that the process reduces bias in the delivery of the system, and again, that the repeat players are not at an advantage over the one-shot players. Informed participation is an important principle because they want to make sure that an active effort is made to ensure explicit disclosure to all parties of information about the risks and the benefits of the process, that the participants are competent enough to evaluate and to understand the risks and the benefits that are being told to them, and that whenever possible that they voluntarily agree, to the point that the mediation may be court ordered or court mandated, that this too is conveyed to the participants so they understand that they don't particularly have much choice in the matter. In terms of innovation, the folks want to make sure that the processes, the design, the implementation continually improves itself and will provide services and benefits more fairly and more effectively, so that, again, everybody has access to justice. With respect to integration, they want to make sure that the system, both internally and externally, works seamlessly. In terms of legal obligations, they want to make sure that the process complies with all the laws of the jurisdictions. And remember, I said that many of these are cross-border, so they want to make sure that the parties are aware of which laws are applicable and which laws are going to be in force in the particular dispute resolution process. Neutrality is self-evident, that they want to make sure that the practitioner of the ODR process functions independently from the disputing parties and discloses any conflict of interest as soon as possible. Protection from harm is important in that the design and implementation of the ODR dispute resolution process should seek to prevent and minimize harm and risk to those partaking in the process, and again, to protect those that might otherwise be marginalized or have their voices silenced. Again, it wants to level the playing field and make sure that everyone has equal voice. Security is an important one. It wants to make sure that all reasonable efforts are made to ensure that the data and the communication between the parties is secure to the fullest extent, And the last, but certainly not the least, is transparency, that everything about the process is made very transparent to the parties, including, the form and the legal jurisdiction of the process, the identity of the parties, the data security, the confidentiality, and whatnot. So these are the basic principles that were created way back when in terms of the design and implementation of any online dispute process. And I know it's somewhat academic or somewhat esoterical, but I wanted to go through it to kind of give you guys a flavor of where these ODR academics are coming from. Now, the next one is out of these principles, the International Council came up with standards of practice that are aimed primarily at behavior. And you'll see that many of these standards are almost identical, if not identical, to the principles that we just used, that we just went through. For example, the first standard is accessible, and the ODR must be easy for the parties to find and participate, and it should be available in all forms, be it by smartphone or desktop. It should be at a minimal cost, and it should be easily accessible to all parties, no matter what their level of computer competency is, whether they are a first timer or this is their 50th Zoom mediation this week. Next is accountable. Again, it must be accountable to all the institutions, the legal frameworks, and the communities that they serve. The practitioner should be competent not only in doing the ADR process, but also in the legal and the technical aspects of using the ODR process, and also to be competent in the language and culture. Because again, and I know I'm sounding like a broken record, oftentimes these will be cross-border disputes, and so the practitioner must be aware of the different cultures involved and or the different languages. The next standard is confidential. Again, the process must maintain the confidentiality of the communications, and if the data is to be shared, to make sure that they say what policies will be made in terms of who will see the data and what data can be used. The next is equal. Again, all participants should be treated with respect and dignity, and again, make sure that the playing field is level, and to make sure that there is no improper power imbalance. Again, the neutral should treat everybody with due process, with respect, without bias or benefit for or against individuals. Legal, again, the process should abide by all the laws of the relevant jurisdictions. Again, the system should be secure, so that it is not shared with any unauthorized parties. And if there's a breach, the parties should be told about it as soon as possible. Transparency, again, this is the last but certainly not the least, that there should be explicit disclosure about everything, particularly about the risks and benefits of using the ODR process. So those are the standards to think about. And if you would like to get a copy of all these, if you go to icodar.com, you can get a copy of the principles and the standards, and also of the next slide. These folks came up with the practical guidelines, or the do's and don'ts, of doing online mediations. And their first one is accessible, that you should initially confirm with each party whether they even want to use a Zoom or a WebEx platform, whether they even want to use the video conference as a platform to conduct their mediation. And if they do, make sure that they have an effective connection, that the audio is clear, the video is clear, that there's decent lighting. For example, I know I'm a little bit dark. I probably need to improve the lighting where I am. Make sure that they have good bandwidth, that their computer has the capacity to do it rather than using a computer that may be 10 or 15 years old. Use a platform that is free to the parties. You should send reminders both 2 days and 2 hours before the start time to remind the parties about the upcoming online mediation. The next is competency. Practice the software before the mediation. Make sure that you yourself are comfortable with it. And if necessary, do a trial run or a dress rehearsal with the parties so that they too feel comfortable with it. Discuss with them the ethical obligations and address it with the parties. Set some ground rules and discuss the ground rules with the parties. And these ground rules are those that would apply particularly to online mediations that may be separate and apart from the normal face-to-face mediation that you would do. And so that is something that you need to think about. Confidentiality. Let the parties know that you will not record either by video or audio the mediation. Get a written commitment from them that they won't do the same. Also get a commitment from them that they won't take screenshots. If the parties want to show a document or a photo during the mediation, have them use the share screen feature as opposed to email, because the share screen feature will be a lot more secure than emailing it. And then once everybody has joined, lock the room so that you can't have interlopers or Zoom bombers showing up. The next one is fair and impartial and neutral. You might want to begin the session sort of as a joint session. I know at least here in California, everybody likes to start in caucus so that the parties never really see each other. But you may want to start as a joint session so that everybody knows that everybody's there. Make sure everybody's audio is clear, their video is clear. If at any point during the mediation, if one party's audio or video disconnects, wait for them to get back on and then repeat whatever you think they've missed. For those of you who use Zoom, when you get the Zoom invitation, you notice that there are telephone numbers. Make sure your parties are aware of those telephone numbers so that if for some reason they cannot connect via the computer audio, that they can use the telephone number to connect with you. That is, make sure they know about Plan B or backup. You may want to start the mediation 10 or 15 minutes ahead to log on just to make sure there are no glitches and to troubleshoot any problems that may arise, to make sure your audio is working, your video is working, etc. The next do's and don't guidelines is security. Again, to make sure that your platform is secure. Don't use apps that require location sharing. Make sure the parties are not using apps that require location sharing. And if they do, have them turn it off. For those of you who might be using the free Zoom, I don't know if you realize it, but when you have more than 2 people, it closes down or times out after 40 minutes. So you may have to, if you're going to do an online mediation or anything that takes more than 40 minutes, you may have to break down and pay the $142.99 for a pro license, which will give you unlimited time. Because the worst thing you want to do is to be in the middle of a mediation and have it close down on you after 40 minutes. So make sure that you're not using some sort of video conference platform that ends at a set amount of time. So, having gone through these principles and these standards, what I'd like to do is talk about some issues that arise under the different model standards of conduct for mediators. And these model standards were created originally in 1994 and were revised in 2005. and they are the joint effort of the American Bar Association, the American Arbitration Association, and the Association for Conflict Resolution. They are values, they are aspirations, as many mediators know. They're not rules, they're not set in stone, but they are something that mediators should aspire to use and apply during mediations. And the first one is self-determination, which I think is probably the most important. A mediator shall conduct a mediation under this principle, which is the act of coming to a voluntary, uncoerced decision in which each party makes a free and informed choice as to process and to outcome. And this raises a bunch of issues. And the issues that it raises is, first and foremost, do the parties even want to use the video conference platform? I've had a few mediations and the parties wanted to use telephone. I don't know if it was the fear of the unknown or what, but they did not want to use the video conference platform. So that's the first question you need to ask, is whether they even want to use it. If they do, the mediator must make sure that the parties understand the risks and the benefit of using the technology in terms of security and privacy issues. They also must make sure that the parties are literate in using the computer technology. Is there a power imbalance? Because as I mentioned, one of the people, it may be their 50th Zoom mediation that month, whereas the other one, it is the first time that they've ever done a video conference. You also want to make sure that there is equal access in terms that they have a sufficient bandwidth. I know I have attended various trainings and they have all told me not to rely on my Wi-Fi, but that I should create a separate Ethernet connection to make sure that I do have a strong internet connection. The other issue is the bias of the mediator to the particular technology. You may have some mediators who are very adverse to the technology or are Luddites, where other mediators are very pro-technology and they may be very pro towards a particular platform such as Zoom or WebEx. They may even have a financial stake or an interest in the technology. And so they're pushing one technology over another. The other thing, and I will mention this again, is whether the mediator is taking on the technology as an overhead cost and is absorbing it. You know, for example, as I said, the Zoom license is $142 a year or $149 a year, which is a cost, you know, that I would simply absorb, or whether they are passing it on through their fees to the parties. And again, this is something that should be made known to the parties. The next, in all of these model standards, there's like 4 points that you should always think about. And one is which platform to use, preparing the parties to work online, preparing yourself to work online, and then the conduct of the sessions. And so you should look at these standards from those 4 points. The next is impartiality, which kind of speaks for itself, that a mediator shall conduct mediations in an impartial manner, which means freedom from favoritism, bias, or prejudice. And the mediator should avoid all conduct that gives the appearance of partiality. And so the issues that may arise under the standard is, again, a bias towards, is the mediator being biased towards the computer literate versus those with little or no experience? And at the same time, I don't know how many of you have done mediations with people representing yourself. There may be a tendency as a mediator to try to help that person because they are representing themselves, and to kind of not cross the line into partiality, but to get very close to it. And the same thing may happen with those who are not computer literate, that the mediator who may have technology savvy may be bending over a little backwards to try to help the first timer, so that it may appear that the mediator may be a bit partial to that first timer. Again, you have the bias of the mediator to either push the use of specific technology or to be adverse of it. The technology should be used in an even-handed manner, which gets back to the bias for or against each party. There are cultural differences in the way technology is built. There may be some North American assumptions built into it, so the mediator should try to look for a platform that does not have such assumptions built into it, or that is more of a level playing field, so to speak. And then we come to social media. A mediator may be deemed partial, that is not impartial, through their use of Facebook or LinkedIn. If you friend a party, or by tweeting an opinion, or doing likes or not likes. This has come about, at least with respect to lawyers under the rules of professional responsibility. There have been some cases, both pro and against, that is, disqualifying and not disqualifying lawyers and judges who may have friended each other. That is, you have the lawyer and a judge have friended each other. The lawyer then appears before the judge, and the other lawyer seeks to disqualify either the judge or the lawyer once he finds out that they are friends on social media. Some cases have said they should be disqualified. Some cases have said they shouldn't be, that, friending on Facebook is no big deal. So the use of social media as by mediators should be carefully used, because it may be viewed as impinging on your impartiality. The next is conflict of interest. And again, a mediator should avoid all conflicts of interest or the appearance, and it can arise either from the subject matter of the dispute or due to the relationship, whether it's past, present, personal, or professional, between the parties. The mediator should make an inquiry into the facts and should disclose the conflict as soon as it's known, whether it's before the mediation, during the mediation, or even after the mediation. Subsequent to the mediation, the mediator should be careful about forming relationships with any of the parties, because it may impinge or raise a question about the integrity of the mediation. So again, conflict of interest, this will raise pretty much the same issues as a face-to-face. Is the mediator using social media, which I just discussed? Has the mediator disclosed any financial or other interest or stake in the platform or provider that the mediator needs to disclose? The other issue is what is the relationship, if any, between the mediator and the fourth party, which is the technology itself, and the fifth party, which is the owner, and that needs to be disclosed. Conflict of interest is important because there was a recent Federal Ninth Circuit case called Monster Energy Company versus City Beverages. A JAMS arbitrator, the Ninth Circuit, vacated the award of a JAMS arbitrator because the JAMS arbitrator failed to disclose to the parties that it had a financial stake or was a shareholder in JAMS, and also failed to disclose that one of the parties had a substantial business relationship with JAMS, or in essence was a substantial repeat player. So if the mediator does have a financial stake in the video conference platform, it's important that the mediator disclose it. The next issue is competence, which I think is fairly self-evident at this point, that the mediator should have the competence in the technology as well as in the dispute resolution skills, and should take the training to acquire the skills needed. And if during the mediation the mediator realizes that her skills are not up to snuff and that she's having issues, she needs to address that immediately with the parties and take steps which would include perhaps withdrawing or requesting appropriate assistance. So the issues this raises are fairly obvious. Is the mediator comfortable with the platform enough so that the technology will not get in the way of resolving the dispute or interfere with the substance or the process? And the same applies with the parties. Are they too comfortable enough so that the use of the technology does not interfere with them resolving the dispute? I'm going to skip confidentiality for a moment, which is standard 5, and go to quality of process. And this too is a very important standard, I think, as many of you know. The mediation should be conducted in a manner that promotes diligence, timeliness, safety, procedural fairness, competency, and mutual respect of all the parties. And the mediator should promote honesty and candor among the parties and should not knowingly misrepresent any material fact or circumstance in the course of the mediation. And number 10, I think, is very important, because if a party appears to have trouble comprehending the process, the issues, difficulty participating in the mediation, the mediator should explore the circumstances and potential accommodations, modifications, or adjustments that could be made so that the party could continue to participate in the mediation and exercise self-determination. And again, this is very important with respect to the technology being used and whether the party is having issues with the technology. And this standard raises a whole host of issues. One is, again, procedural fairness. Is one party being disadvantaged by the use of the technology? Who else is in the room? Do you have unauthorized listeners? I don't think many of us are using cameras that have a 360-degree angle, that is, that you see the entire room. So there may be somebody in the room that is outside the view of the camera, or somebody may have their smartphone turned on so that somebody else can be listening. So you may have unauthorized listeners. You may have Zoom bombing. You may have, as I said, somebody unauthorized may be doing the recording. The other issue is whether a mediator can control the unruliness of a party. Suppose one party starts yelling and screaming at the others. Does the mediator have a plan B to control that? Or suppose one party is not responding because they are having technical difficulties. Again, the mediator must be able to take steps to make sure that that party can respond, can participate in the mediation. You have privacy issues as well. The mediator must make sure that the platform being used is a secure and is suitable for the parties, promotes a quality process, and is trustworthy. And so, as I said, the quality of process does raise a host of issues. But I think more importantly, and the more tricky one, is the confidentiality. And as you all know, with the beginning of the COVID in March, everybody had concerns about whether Zoom or other video platforms were secure enough to protect the confidentiality of the mediation. And I think at least Zoom responded by upping its game and putting in protocols or coding it so that it is a lot more secure than it was way back in March. So under this standard, stating the obvious that the mediator shall maintain the confidentiality of all the information told to her by the parties unless the parties consent that it can be disclosed. And what this means that even to the extent that the mediations may be court-ordered or court-mandated, the parties cannot tell the court any details of the mediation. They can only tell the court whether the parties appeared and whether they settled. And what it also means is that when a mediator meets with people in breakout room number 1, the mediator cannot then tell the people in breakout room number 2 what she was told by those in the first room, unless those in the first room give their consent. So the issues that this raises, again, the mediator should be aware of the security standards being used by the platform, including the protocols. And to some extent, it will be beyond the control of the mediator, because you may have Zoom bombings and glitches in technology, which are more or less up to the fourth and fifth parties. The mediator must be able to explain in understandable terms the perceived and actual risks to privacy and confidentiality inherent in the mediation. The mediator obviously should not use any platforms that has issues with security and privacy. The mediator should be careful about others in the room or listening in, and the mediator should use the waiting room function and let in only those who are authorized, again, to prevent interlopers. And the mediator should not stay logged in or while away. There's also the power imbalance issue, that the parties may not be equally competent with the computer's typing speed, available bandwidth, language, or frequency. The mediator should create an agreement to mediate, setting out the parties' understanding of the process, the technology being used, the risks involved, and the ability of the mediator to protect confidentiality. And there are some good samples. In the spring of 2018, Amanda First, that's F-I-R-S-T, wrote an article in the Harvard Negotiation Law Review, which is volume 23, page 405, entitled A New Agreement to Mediate, Guidelines for Ethical Practice in the Digital Space, and her appendix A, B, and C has sample agreements to mediate online. So for those who want to take a look-see and maybe do some cutting and pasting, again, it's the Harvard Negotiation Law Review, volume 23, page 405, and it's the spring 2018 edition, and it's Amanda First. And her appendix A, B, and C have sample agreements to mediate online. The next standard, advertising and solicitation. Again, a mediator should be truthful and not misleading about advertising or other communicating her skills and experience, which, in essence means that a mediator shouldn't say that they're comfortable with using video platforms when they've never used it or don't even know what Zoom is. They shouldn't include any promise as to outcome, and they shouldn't solicit in a manner that gives the appearance of partiality or undermines the integrity of the process. The next one is fees and other charges. The mediator should provide a complete, written, detailed information about fees, expenses, and other actual or potential charges that may be incurred in connection with the mediation. And if the mediator has, again, it should be in writing. And while the mediator can charge fees unevenly or an unequal fee agreement, the mediator should make sure that it does not affect her impartiality. I know many times you may have a defendant picking up all the fees, which is fine, but the mediator must make sure that it doesn't affect her impartiality or otherwise affect the integrity of the mediation. So the issues that are raised under these two is, again, is the cost of the platform a overhead cost being absorbed by the mediator, or is it extra? And if it's extra, the mediator should disclose it. is the mediator an investor in the platform, or does the mediator derive a financial benefit? Again, this must be disclosed. You have the social media issue, which we discussed. And finally, is the mediator misrepresenting her comfort zone with the use of the platform? Is she overstating her ability to use it? And with that, I am done. And we can either go to some hypotheticals or answer your questions and answers. According to my watch, we have about 10 minutes or so left. So Jeff,
Phyllis,
I will
yes,
send it back to you.
Phyllis, that was terrific. Thank you very much. I'm sure everybody learned a lot from that, a very comprehensive review. I want to remind everybody this webinar is part of the Will Work for Food project. We don't charge for all this information and this great education. Rather, we ask people to contribute to a food bank of their choice if they like what they see, and how could they not? So please contribute to the food bank of your choice in honor of Phyllis, this great presentation, and the whole Will Work for Food project, which has been pioneered so wonderfully by Natalie Armstrong. So with that, I think if people have questions, we ought to take the questions. We have a manageable crowd today, so if people would simply like to unmute themselves and pose a question to Phyllis, I think that would be great. And if nobody has a question, Natalie and I will have to ask some questions.
No, I tell you what, Jeff, let's go through a hypothetical. Maybe I can get some people.
Okay, sure.
Okay.
Go ahead, Phyllis.
Let me get back to screen share. I'm going to skip the first hypothetical. Let's go to the second. You are conducting a group intervention in a federal government workplace. One of the employees is participating by teleconference, and the others are actually in the room. What ethical issues do you guys see that this raises?
Well, I would think, Elliot Hurlin here, I would think that the person attending by phone would need to know who's present in the room, correct?
Yes. What other issues? Does anybody see a issue in terms of quality of process, and that those in the room may need to see who else may be listening in or the telephone?
I also think that the issue of confidentiality will come up here, because those in the room will overhear what he's discussing with the person on telephone. And if he needs to talk to the person on telephone, maybe he should excuse himself, maybe go to another room or something.
Anybody else? Do you think there is a issue of a power imbalance, and that the people in the room may have an upper hand vis-a-vis the mediator, so to speak, versus the one on the telephone, sort of out of sight, out of mind type of thing?
Well, I think there, again, the mediator's job would be to level that playing field and make sure that there isn't an imbalance of power. Certainly the mediator would recognize the imbalance of power, and the question then for me would be, how do you level the playing field?
You have any suggestions?
Well, I think having breakouts, confidential communications with one side or the other to provide some support to the person that's on their own, and also to caution those in the larger group to avoid that privilege that they are enjoying, and letting them know that that won't be something that will affect the mediator's impartiality.
All right. Anybody else?
I'll say something, Phyllis. I
Okay.
don't have as one of my goals to balance the power. This is something I learned from Jim Melamed about 20 years ago. Because I'm impartial, I simply try to maximize each party's power, but it's quite common that there are imbalances just because of the nature of supply and demand. One party may have more leverage in a transaction. So I seek to maximize each party's power, but I don't worry about whether or not it's balanced or equal. It frequently won't be equal.
You know, in response to that, Larry, I'm wondering if we have different definitions of power. I can see the power of a person's legal position and the mediator not ignoring that power in describing the advantage or disadvantage of that legal position, or the defenses regarding or the claims regarding the main issue. Phyllis, are you talking about a different sort of power, more psychological in nature, as opposed
I'm just using the term power and balance as it's normally used in any type of mediation training. I'm I'm not putting any particular definition into it. Any other thoughts? Well, let's take a quick look at number 3.
Phyllis, I don't think your screen share is operating yet.
Okay. I'm trying to figure out how to get out of this. Let me give you hypothetical 3. You're mediating a dispute with the parties in 2 locations. When you all meet over video conferencing, one of the parties does not have their camera on, but you can hear them clearly. So you have one with audio and video and one with audio only. What issues do you think this raises?
Well, in law school, I was quite the hand raiser, not very comfortable with the silence. So I would oftentimes raise my hand and participate. I wonder if one possibility would be to turn off the video and have both sides be audio only. I don't like that as much. I would prefer that I help that person get their audio working. I'm sorry, their video working, so that everyone can have the benefit of the face-to-face. Oh, there's Snoopy.
Yeah. So what issues, when you have one on audio and one on video, you also have the security issue, because you don't know the person who is on, or with both of them, you don't know who's listening in, if they're secretly recording it, and whatnot. And you don't know who else is in the room. Does anybody else have any?
Phyllis, David here. I would have a concern that the person that's not showing their video, is it really that person that is there in the negotiation, or is it somebody taking their place that might
This is true.
that might be more savvy? So they had a stand-in. That would be my concern.
That's a very good point. Anybody else? Unmute. You have to unmute yourself.
Okay.
There.
After exploring other avenues, I may decide to take a short adjournment and ask them to make sure their video and audio and others will be working so that there'll be fair playing ground. We can see each other, the parties can see each other, and if there's cause for suspect that there's a third party or on somebody not invited in the room, I can ask both parties to turn their camera around 360 degrees, so I'm sure there's no other party there.
Anybody else have any concerns? What about confidentiality or security of the platform? Are there any issues you think with competency in that the party who is on audio only may feel incompetent in terms of using the video, or may feel incompetent using the audio, and so maybe having the technology get in the way of trying to resolve the dispute?
Again, I think that the answer of that is, of course. I guess if one was to write an article about all of these things, I would entitle it, "What's a Mediator to Do?" Because all of these things are wonderful, but how do I, as a mediator, in a separate location and not in the presence of, in the complete presence of these people, I can only trust, and I always want to trust that the parties participating in the process are going to be honest about how they're participating. I mean, what is a mediator to do? There's certain limits, I think, on achieving these aspirational goals. I don't know if anyone else has some thoughts on that.
Do you think they're harder to achieve because you are online, you are doing this online, as opposed to face-to-face, a la pre-COVID?
Well, yes. I think that I love online mediation, and I think that online mediation provides all sorts of advantages and allows parties to participate in a way that they might not be able to in an in-person mediation, for a variety of reasons that I guess I don't have time to go into. But in-person mediation does provide you with a great deal more information about the circumstances by which each party has entered the process.
I say something?
Certainly.
It seems to me that if it really is an issue of the person not feeling competent with the technology, I think for the mediator, it raises an issue of whether the mediator should continue with the mediation. If the person doesn't even feel comfortable talking or using the technology. To me, it's just that if the party can't participate effectively, then you should probably just end the mediation and try something else.
Well, that goes back to self-determination, and then paragraph 10 of the quality of process.
Right.
That says, you know, if a mediator sees that a party's having issues, they should make adjustments and accommodations so that the party can participate or exercise self-determination.
Right. So if the party simply doesn't feel comfortable participating on Zoom, maybe the party should discuss whether all of them or that one should go to the telephone.
Yeah.
and just use telephone.
I mean, the one thing I'd like to point out is I've talked to a lot of mediators, and I don't know how many of them ask the very basic fundamental question of the parties: do you want to use Zoom or do you want to use telephone? Many of them just assume that the parties want to do a video conference without asking, and that defeats the whole idea or notion or aspiration of self-determination. And so if you guys walk away from here with nothing else in your mind because you only remember about 20% of what I'm saying, according to neurologists. Ask the parties the fundamental question: do you want to do a video conference or would you prefer telephone? Have them exercise self-determination. Don't assume.
I think that's a very good point. It's something that I've learned with my students since March, is that some of my students simply don't want to use Zoom. They'd rather have the telephone call. And it goes into my own bias. I like seeing the people and I prefer the Zoom, but my students don't want it. And so I do, whenever the student wants to have a conference with me, I ask, do you want to do it by phone or Zoom?
Yeah,
And
I think that,
most of them want Zoom, but some of
yeah,
them simply don't.
but you have to ask, particularly mediating parties, because they come in all different generations, shapes, sizes, computer literacy, etc. And I think with that, Jeff, I am out of time.
Phyllis, we are indeed out of time, and I want to thank you again very much for a very comprehensive and interesting and educational presentation. I want to remind everybody again that this is part of the Will Work for Food project, initiated and developed and organized, developed so excellently by Natalie Armstrong. If you like what you see, please contribute to a food bank in your locality in honor of Phyllis's wonderful presentation. Natalie, we've raised, what, about $35,000 so far to fight food insecurity around the world? Is that right?
We have, in fact. Our industry has been incredibly generous.
So congratulations and thanks to everybody. We have some of our regulars and some first-timers on the call. We hope everybody enjoyed it and is moved to contribute to a food bank and combat food insecurity, such a serious problem in our society. Natalie, thank you. Phyllis, thank you very much. And with that, we are complete.